Welcome to today's episode of the MP Access podcast. My name is David Wharton. I'm the editor-in-chief of Mortgage Point and of the Five Star Institute. For today's episode, we are talking with David Demers of Cook Demers LLC, one of our Legal League firms, and as of last summer or so, the current chair of Legal League. Welcome, sir.
Thank you very much, and that's correct.
Excellent. Well, thank you for taking some time to talk to us today. Let's start out kind of at the beginning. So tell me a little bit about, for those people who may not know you, may not have worked with you, what was your path into defense litigation, creditors' rights, and what you do? What led you from there also then on to the establishment of your firm, which I think was back around 2001, if I'm not mistaken?
That's correct. Yeah, so I've been practicing law since 1991. It started out, I'm very competitive. I played college basketball, so I wanted to get into a field. I always wanted to be a lawyer, but I wanted to get into a field that was competitive.
Okay.
And litigation lends itself to that. You know, there's always a winner and a loser. There's the challenge of the argument, the debate, which I always loved. So I started out in a litigation firm in Columbus, Ohio, and transitioned to a really large firm in Ohio. We had 250, 300 lawyers, and then I got married later on in life. And
congratulations!
Right, right, and had kids later on in life, and which I think was a good thing. Because there's got to be a work-life balance, and when we had for our son, I decided, like, listen, I probably should do this on my own so I can have a little better work-life balance and open an office just outside of Columbus, and we've been there for 20-some years. So,
how old were your kids when you made that decision?
My son was 2, and my wife was pregnant with our daughter.
Okay, we were staring down the barrel of a many-year commitment there. Yeah,
and I look back at it, and I'm like, boy, you were stupid, because it was a big risk.
Sure,
but it's been great. I live a mile from my office. I was able to attend all my kids' activities, or as many as I could that work would permit, and it was. I'm very happy with the transition.
Well, looking at just the scope of your work over that time, you focus heavily on creditors' rights and litigation, and I know you do bankruptcy focus as well. Could you talk about what specifically drew you to this niche and what appealed to you about it? What do you enjoy about it?
I enjoy the art of the argument.
Okay. So
I started out doing just general defense litigation, and it kind of morphed into products liability, wrongful death, serious injury, which I still do some of that. And then, I had a friend of a friend who said, hey, we need somebody to do this work in manufactured housing. And it went from manufactured housing to the creditors' rights to doing their litigation, and I've litigated the creditors' rights in arena in Ohio, Indiana, Pennsylvania, gone down into Kentucky, out to Nevada. So that's kind of it evolved over a period of time.
How much did you know about this kind of sector when you were starting out on that journey? Was it something you knew in passing? Did you have to research? And what were there any surprises as you kind of get into it?
I think litigation is pretty consistent from, doesn't matter what you do, if it's personal injury litigation or creditors' rights defense litigation, but it's learning the nuances of the industry. You have to learn the alphabet soup of creditors' rights litigation, FTCPA, RESPA, TILA, FICRA,
all the acronyms.
All the acronyms. And then just learning what the clients are looking for.
Okay.
What's the outcome? I mean, in general defense litigation, the strategy is to get your client out for the least amount of money or win. And you have to talk to your clients and ask them, what is it that you were looking for from this? I mean, because obviously they're always getting sued. And, some of them will, I want to fight this to the end. Others will be like, let's just get ourselves extricated from this case as quickly as possible for whatever reason that may be, a minimal settlement. They maybe have done something wrong and they're like, hey, listen, we got caught. We need to get out of this. So
you talked about that competitive mindset, is that ever something you have to kind of like tamp down if that's not the goal? Like, or is it just about translating what a win looks like in a given situation?
A win is what the client wants.
Okay.
So that could be a settlement. That could be, going all out and taking it to trial. I've tried upwards of 100 trials to a jury trial. So I've done a lot of that. I always tell my clients this: I don't make decisions. I give you opinions based on the research that I've done. The ultimate decision on what you want to do lies with the client.
Right.
And then the client gives me instruction as to what they want out of this, and I'll do my best to get there.
Sure.
Whether it be a monetary settlement or something else.
Yeah. Well, you mentioned your jurisdiction crossing across state lines, Ohio, Indiana, Pennsylvania, probably some others that I don't know about. But how is that experience working multi-jurisdictionally shaped how you approach working with servicers and lenders specifically?
Well, within each state, there's different jurisdictions. So, use Ohio, for example. We have the Northern District, the Southern District. You have to learn to adapt to what the judges are like in each jurisdiction. If you're in federal court, if you're in state court, obviously there's county judges and everyone. So you learn to adapt. You kind of bob and weave and figure out and do your research.
Yeah.
Do your research on who's the judge you're in front of. What is the judge looking for? What is the judge? If it's a creditor's rights issue, is the judge more debtor friendly, more creditor friendly? What is the judge ruled on a similar case in the past? It's doing your background, your homework, and that doesn't matter to me. It doesn't matter where I'm at. That's the baseline of what you have to do, and only when you know that can you explain to your client, hey, here's the risk-benefit analysis on this and how we think you should proceed.
Well, we mentioned that you took over as chair of the Legal League here this last summer. Obviously, that's a transition where you're picking up taking the baton from the previous chair and kind of thinking about what you want to accomplish. So what were some of the priorities and goals that you set for yourself coming into that? Well,
first of all, Steve Hladek did a wonderful job with that. So, I know a lot of people use this saying, you have big shoes to fill. I really do have big shoes to fill. And I didn't go into it thinking that I wanted to make change. I wanted to be open-minded, get an idea as to, what's going on in the industry, what's going on with Legal League, listen to the members of the Legal League and what are some of their concerns, and then implement those if it's possible.
And how long has your firm and you personally been working with the league over the years?
10 to 15 years.
Yeah.
We've been, a member of the organization and, mainly in the background. I'm also the head of the education committee, so I get involved in that. I'm on the SWIG committee, so writing papers. And, I think like anything, it's kind of like my practice of law. I do my research. I don't try to be out front, and same thing with Legal League. I tried to get involved, listen, and not just jump into it without really understanding what the organization was. And only when I thought that I had a better understanding of what the organization was and what it can do for the firms similar to my size that aren't a national firm, what their concerns are with respect to what's going on in the industry.
Well, with that more behind-the-scenes mindset and having worked with him for a few years, what was it that made you want to step forward? Was it just you decided it was time, or you felt you were comfortable and could bring something to it? What was it?
I think that's it. I think it was time to move forward and see if I could take a more active role in Legal League and listen to what other people were saying and their concerns, and said, I'll be the spokesperson or the mouthpiece for that, because I don't have a difficult time sharing what my opinions are. So
Sure.
Sometimes that's good, sometimes that's not so good.
It could go either way.
It could go either way. That's correct. But that's kind of my mindset with that. I wanted to learn about the Legal League and the 5-Star and what they are providing and how they're different from other organizations. and that was kind of my mindset going into it.
Well, if you can take yourself back to when you were first crossing paths with the league, what was the sort of reputation? What brought you to it? What did you hear about it that made you interested? And how did those expectations play out as you've been involved with it over the years?
That's a great question. And I looked at other organizations and as you know, David, there's many of them out there, and each of them offers their own unique spin on what's going on in the industry. I thought this was more of a grassroots organization, and that's what really appealed to me about it was, they were really concerned about everybody, all firms, big, small, medium size, listening to what the concerns are. It wasn't, when you go to a conference with the Legal League, you go and you learn, and that's what I like. I like the education part of it. So others, it's more of a social. And that's not a downside to them. That's just not appealing to me.
Okay.
So this is what attracted me to Legal League was, the education, learning. I've been practicing law for over 30 years now, and my wife is always saying to me, David, you need to, why don't you retire? Why don't you slow down? And I'm like, I still like it, and I don't feel like I've been practicing 34 years.
Yeah.
So I enjoy the education part of it. I enjoy learning. I enjoy interacting with the clients and listening to what their concerns are and the other members. So,
are there any aspects or benefits of the league that you think members may overlook or not take advantage of as much that you want to shine a spotlight on?
Yeah, I think participation.
Okay.
I think participation is a big thing that, I'm sure we say it as parents to our kids, you only get out of it what you put into it.
Right.
And I think that the more you put into this organization, the more you can get out of it by becoming involved in whether it be the education committee, the events committee, the SWIG committee. There's plenty of opportunities to be involved and have your point heard. And not everybody's going to agree with what your point is, but it gives there is no, the proverbial, there is no wrong answer.
Sure.
It's about what would you like to see change, or, whether it be a SWIG paper on a particular topic that maybe I never had been involved in before. What you get involved, learn, write. And Legal League promotes that. Gina Galusha does a wonderful job trying to get people to, write an article, speak at a conference, get on a panel. I mean, those opportunities are there for everybody that is a member of the Legal League, not a select few, but everybody. And that's appealing to me.
Sure. Well, we mentioned there's no shortage of acronyms in your sector of the world or in the industry at large, but you thrown out SWIG a couple of times. So for people who are watching who maybe don't know what that is, could you talk a little bit about what that committee does in particular, and also about what the education committee does?
Sure. SWIG, the strategic initiative, is what they do is they write articles. They write, white papers on topics. We just did one on the statute of limitations. We did one on AI, and they're more bullet point papers that are educational tools for our membership. So, at the Spring Summit, at the 5-Star Conference in September, they're put on, and we've done those, FEMA relief, what do you need to qualify for that? Well, all little bullet points that help our clients who we report to, provide them information and topics that maybe they're not in tune with, or maybe a paper that may be interested for Florida and California because they have more natural disasters. Well, but people that you never know if you're an employee who may get mortgage loans in that jurisdiction where you have to do it. The education committee, we just came from, educating, providing 2 days of classes to a client about topics that they wanted to know more about. We have for lack of a better term, a buffet of topics that we provide, and we bring members in to sit in a classroom and educate the clients on this was on, basically advanced foreclosure was yesterday, and today was, bankruptcy issues with the new rules that just went into effect on December 1st. And we have, I don't know, 20, 30 topics that we just will give to clients who approach us, or we approach them and say, hey, listen, would you like to be trained on any of these things? And that, again, David, goes to the exposure that if you're a member, you can participate in. If you want to get in front of somebody, maybe to improve your speaking skills, maybe to educate a client, maybe to be educated yourself. I had the privilege of emceeing the training over the last 2 days, and it was educational for me because I got to listen to things that I wasn't completely up to date on.
Well, we talked a lot about some of the benefits that the league brings to its members. Could you talk a little bit about how the league can help both firms and servicers navigating what is, I'm certain, an increasingly complex regulatory landscape? I know we've had the CFB with a big question mark after it. We've had state-level CFPB equivalents. So how do you keep up with all of that, and how do you help your clients and other firms learn and kind of keep track of all of that?
Yeah, I think that's a wonderful question because there is no simple answer to that. At the Five-Star Conference that was in September, one of the issues is, everybody was saying for a while, oh, good, the CFPB will be gone, and then there won't be that the thumb over all of the servicers with regulation and worried about audits and stuff like that. Well, then when we thought more about it, you're thinking, well, now there's 50 AGs who may be out there coming after you where the CFPB wasn't. So be careful, the proverbial be careful what you wish for.
Yeah, now you have 50 different standards or 50 different versions.
Correct. So, it's constantly evolving. The regulations with, what notices you have to give, when do you have to give them. Each state is a little different. Again, educating the clients on what is required for their jurisdiction. Yesterday when we were doing training at a client, we educated them on the fact that, with a foreclosure, if you don't start it right the first time, you can't correct it. Unlike other litigation where you can file an amended complaint or something, you have to get it right. And if you get it right, it makes everything else afterwards go easy. So impressing upon the clients that, this is the way you have to do it and making sure they follow that. And it makes it easier on them. It's not because we're, as lawyers, trying to make their life difficult. We're trying to work in sync with them to make sure that they know what they need to do to keep themselves out of getting a alphabet soup lawsuit filed.
Well, speaking of the alphabet soup, I know you've defended against claims involving some of those acronyms, TILA, RESPA, FCRA, just a lot of them. So are there areas within kind of that large umbrella of alphabet soup, to mix my metaphors, that are causing the most litigation pressure for servicers? And if so, what's happening on that front?
I don't see it as much. I mean, I think there are. I mean, at one point in time there was the TCPA, Telephone Consumer. Those have kind of gone by the wayside.
Yeah.
They there's an ebb and flow with any of them. I think the RESPA and TILA ones are probably the ones that you see the most, because those are the ones that you can slip up on the most. Did you communicate with the borrower and didn't give them a mini Miranda warning? Did they close on a document and they weren't fully advised of what was going on? Those are where you can get tripped up on.
And is that mainly just because there's so many boxes you need to check and you just have to make sure you're hitting every single point?
Correct. Yeah, and if you don't hit them all, you're invariably going to get the letter.
Yeah.
I'll give you an example. I was sued personally years ago because I was talking to a lawyer and I sent him a letter that he asked me to send, and I didn't put him a mini Miranda warning. I mean, as ludicrous as that sounds, and it worked out in our favor. There are lawyers out there. That's all they're looking for is a technicality to sue you, and you have to deal with those. And again, it kind of goes back to what we were talking about at the beginning, David, where I said my job is not to make decisions for the client. My job is to give the client their options as to what they can do. And in those situations, we say, listen, is it better to pay $1,000 or do you want to litigate it? So when you get presented with that, even if you're in the right, it may be better to settle the case because you're going to spend so much money in court.
Right. Well, looking at the year that we're rapidly approaching, or even anything from this past year, are there any particular cases or regulations that have really loomed large that servicers should be aware of? They may not have on their radar.
Yeah, I think the two things that I see, we call them the zombie loans. I'm sure you've heard that term, and those are basically the old dormant second mortgages that sat out there forever, and then somebody buys them and starts to try to collect on them. A lot of states now are starting to, not a lot, but a handful of states are starting to create statutes for that as to when you can do it.
Okay.
The servicers really need to be mindful of that. And as we were discussing with the client today, with the new bankruptcy rules going into effect December 1st, and the implications of what those mean to the servicer and the new forms that have to be used, they need to be really on top of that, because if not, they may be subjecting themselves to some complaints filed in bankruptcy court.
Is there a quick way to kind of summarize some of those changes that are coming up, or is it really just nitty-gritty details?
I think it's nitty-gritty details is really what it's going to be. And not to sit there and promote the lawyers, but, the clients need to make sure that they communicate with their local counsel on what these changes are. And each judge may implement them a little bit differently as to how the forms are supposed to be completed. Using the zombie loans, one judge may look at them completely different than another judge. So making sure you have your pulse on what's going on in the state that you're working in.
Are there any, beyond kind of what you've talked about there, are there any areas of bankruptcy or bankruptcy law that you find that servicers may have misconceptions about or just don't fully understand about how it works and how it interacts with mortgage servicing itself?
Well, I will say this. I think over the last 5 years, the servicers have really gotten a better handle on the bankruptcy, because it's rapidly changing. It changes all the time, and it changes depending on the jurisdiction. As we were talking about today, those fees that are recoverable, those fees that are not recoverable, those are always a sticking point depending on the jurisdiction you're in, and you have to be mindful of that. And it kind of goes back to the training aspect of the education committee that I was talking about. Making sure that your employees are properly trained, whether it be in-house or by outside counsel, making sure that they're properly trained, and then that avoids some of the pitfalls that come with that.
Well, I know one of the big topics in the news obviously has been prices and affordability and all this ongoing discussion of just people struggling to keep up. Are you seeing that? How are you seeing that spill over into the bankruptcy and the foreclosure side of things? Are you seeing those trends being reflected from those headlines that we see every day of, how is that impacting that
100%.
Yeah.
I mean, whether it be foreclosure or bankruptcy, in foreclosure, you will see multiple loan modifications or partial claims that have been filed because people, Mr. and Mrs. Smith bought a house and their monthly mortgage payment was $1,000.
Yep.
And that was easily affordable for them. Well, now with the increase in taxes and insurance, that's $1,500, $1,700 a month, and they no longer can afford it. And that will trickle over to bankruptcy at some point in time because they no longer can afford the home.
Right.
And, I heard somebody say one time, well, not everybody should be a homeowner. Well, I'm not sure that I necessarily agree with that. Affordability is becoming a big issue, not just the price of the home, but the taxes and insurance. Mm-hmm. That you can't estimate what the local taxing entity is going to increase your property value.
Right.
You don't have a say in that.
Yeah.
It's some guy that comes by or woman and looks at an appraisal on your house and says, it's gone up 25%. And you're like, honey, we can't afford this payment anymore. And that's what is creating a lot of problems for the homeowner, especially new homeowners, where they haven't really moved along in their career. They're not seeing the significant increase in their income, and now all of a sudden they're strapped. And they go to other options and realize that when they do a partial claim, well, now we have no equity in our home.
Well, I was going to ask for it seems like the last couple of years coming out of COVID, we had a lot of conversations about how foreclosures largely weren't happening because people had so much equity in their home, so they had options. Are you seeing with the current environment that sort of cushion starting to not be as much of a cushion as it once was with the increases, like you mentioned, in taxes and insurance and the other factors?
I think that's a great question, and I'm more philosophical about it and historical. I look at it, my dad always told me when they were younger, and listen, if you can't afford a house, you need to put 20% down, or you need to do, that was the mantra. Well, now it turned out that it wasn't the case, David, that a lot of people will now buy houses and, they go to somebody and say, hey, this is what you can afford. Right. And hey, you only have to put 2 or 3% down. Well, when you don't have the savings to fall back on, when your home price increase or your monthly mortgage increases because you've escrowed taxes and insurance, that creates a problem. And then when you can go out and get a partial claim and submit it, well, I don't know that they're being fully educated on the fact that you're eating away at the equity in your home, or maybe they don't care and they're ambivalent to it. Well, then they go to sell their home and they realize they're underwater because they've got all these partial claims that are now attached to it.
Is that something that you guys, is that a topic that you guys speak to in your education committee or anything like that? Or is that more of, that more falls on the servicer and just, it's not really in your wheelhouse?
I think we deal with it more on the back end.
Yeah.
Then the front end, like that's a servicer issue, that's a lender issue. That's educating the borrower on knowing what the risks are with home ownership. That your taxes and insurance can go up. Well, if you lived in California or Florida, you may have had your homeowners insurance canceled because they're no longer writing a policy there. Well, that creates for a new home buyer, that creates a lot of problems.
Yeah. Well, obviously, you're working day in, day out with servicers, and they're working with the various firms in Legal League and throughout the industry. Are there areas where you see consistent gaps or challenges in communication as far as how those two parts of the industry stay in touch with each other? Do you see consistent breakdowns in communication there, or areas where there's areas to improve?
Yeah, I thought about that. I've thought about that question a lot, not because you asked it, but over time, like, what's the change in the industry since I started? Well, we used to have a lot more communication with our clients other than through technology. Mm-hmm. And it's as wonderful as technology is, it's so nice to be able to pick up the phone and talk to a client and explain what the situation is, as opposed to sending 10 different emails on that. So I do miss that. I think sometimes there's a breakdown in communication because you can't fully convey your thoughts in an email, that's not a 3 pages long. It would be much easier. Now, I will say that with COVID and the advent of Zoom and, Teams, that, we can get on a call. I do love that ability to say to somebody, hey, can we get on a call and just discuss this so I can answer your concerns? Or make sure that I understand what your concerns are. Right. I think that's important.
Well, I know through the league we have a lot of events that you guys are involved with, the League Summits as well as 5-Star Conference and even Government Forum to some degree. So what does that kind of touch on the same kind of thing of those opportunities to have that face time, or do you find real benefits coming out of those events?
Wonderful question, because what we started to do at the Legal League, I think we've done it twice now. We have a servicer roundtable. We've done it in the spring, and then we did it at 5-Star in September, where we bring servicers in and we bring lawyers in, and we sit around a table for 2 or 3 hours, and we have a bunch of topics that we're going to discuss. And what's nice is to get the feedback from the servicers of what their concerns are, and address what, from a legal perspective, our concerns are, and how we're going to navigate that in the future. And I think that's been really, really a positive of the Legal League, and just getting people in a room and discussing topics of the day.
Yeah. Well, I know we're almost out of time, so I want to leave you with one last question. Obviously, like I said, you're about 6 months into your tenure here as chair. What sort of legacy do you hope that you'll leave when it's time for you to pass the baton on to the next person? And larger than that, what legacy do you hope that the league will continue to build 5 years down the road, 10 years down the road?
It's probably the thing that I've practiced since I started practicing in 1991 is get involved.
Okay.
I really am an advocate for get involved. Your opinions matter. Like a lot of people worry about if they have an opinion, you have to agree with it. I'm not that person. I like your opinion matters. Get in and get involved. Share your opinions, and we can work off of that. Whether everybody agrees with it is not important. Maybe be a little tougher skin, but get involved and let's hear what you have to say because it is important. Whether people agree with it is not what's important. It's that you have an opinion and you're shedding light on an issue, whatever that issue may be, in the legal league. And it may be something that I'll dwell on or some other attorney might go, I never thought about it from that perspective. Or a client who is sitting in the room or a potential client sitting in the room. I really like that insight to that. So that's what I want I want to encourage people to get involved and let us hear your opinions.
Well, fantastic. Well, thank you again, David, for your time today. I know you mentioned a lot of the white papers and other publications, so I would encourage everybody who's watching to go check out the Legal League website as well as themortgagepoint.com. We cover a lot of that stuff as it comes up. And otherwise, thank you for your time, and we will see you here at the summits and the other conferences here coming up in 2026. So thank you, David Demers.
Thank you, David. I really appreciate it.
Absolutely.